You've fallen down a flight of stairs. The reason you fell down the stairs is because one of the stairs was broken. And now you go back to take pictures 2 weeks later, and guess what? It's all fixed. Can you use the fact that it has been fixed to show that the person was wrong for not fixing it earlier? You want to learn the answer? Come join me. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. The answer to your question is no, you can't use that, and here's why. That's something in law known as a subsequent remedial repair. Now, what does that mean? It means that after your accident, the person whose property it was recognized that there was a defect, that there was something broken, and then went ahead and fixed it. Now, you would think that just because they recognized this problem and then fixed it after you got injured, that automatically means that the person who fixed it was responsible for your accident. The reality is, as the property owner, they may in fact be responsible for your accident. But the fact that they have spent the time and effort and money to now fix that problem, that we are unable to use to then show that this is a condition that should have been fixed before your accident happened. Now, why is that? The law says that we cannot use the repairs that are done afterwards to show that this defect existed or that it existed for a significant period of time that should have made the property owner aware that they should have fixed it. Now, anytime you have a fall or trip and fall case where you're falling over a broken sidewalk or something that's defective and broken, what we have to argue is that the owner of the property knew or should have known that the owner of the property had a defective sidewalk or piece of property, and that they should have taken steps to fix that before you got hurt. The other argument we can make is that they should have known, because of the duration in which this condition existed, that you had a broken step or broken sidewalk for an extended period of time, and it's obvious to anybody who walked by, that the property owner should have recognized this defect and should have taken steps beforehand to fix it. But the mere fact that they have now gone ahead and fixed the problem after you suffered your injury is not something that we can use as evidence at the time of your trial. So why do I tell you this information? I tell you this because if you've been involved in an incident or an accident where you've fallen, injured because of somebody's broken property, then what you need to do is to pick up the phone and call. And I encourage you to do so. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.